Mr. Friedenthal, would you like to call a witness?
Yes, Your Honor. The defense would call expert Paul Sanders.
Okay, Mr. Sanders, we could get him on the screen.
I've
There
made
he is.
requests. Mr. Sanders is present in the courtroom, Your Honor.
Thank you. Mr. Sanders, will you please raise your right hand? You do solemnly affirm the testimony you may give in the cause now pending shall be the truth, the whole truth, and nothing but the truth. This you do under penalty of perjury?
I do.
Thank you. Go ahead, Mr. Friedenthal.
Thank you, Your Honor. Good morning, Mr. Sanders.
Morning.
Can you tell us what your occupation is, sir?
I'm called a certified safety professional. I have 35 years of practical experience in accident prevention and investigating accidents. Following my college, I went to Indiana University, but not the one everybody knows about. It's in Pennsylvania. It's a state college called Indiana University of Pennsylvania, and it has a specialty in accident prevention and things like that. And as I say, I've had 35 years in the field.
Can you give us an idea of your work experience, kind of the big items?
Yeah, well, I started out working on the safety side for companies. I worked first for Ford Motors and then for Ford Aerospace. I wound up working for Steelcase in Tucson, California, although their headquarters is in the Midwest. And at about that time, I had also gotten a certificate of occupational safety after 13 credits at UC Irvine. And then I started doing some forensic work, working in the legal field as well, dealing with the causes of accidents. And that deals with industrial work, lighting, retail store safety, and, accidents such as this.
And in this case, did my office retain you to be an expert in this case?
Yes, you did.
Can you just briefly tell us what you reviewed in order to prepare for this, your opinion, to come to your opinions and conclusions in this matter?
Well, I reviewed a great many things. Certainly, I went to the store and examined the store. I saw the video multiple times. I read the depositions of the witnesses. I read the medical records of Ms. Mulligan. And many other documents, that some of which have been referred to already.
Now, when I ask you for your opinion, I want you to only give the opinions that you're reasonably certain, with a reasonable degree of safety professional probability. Okay, I don't want you to guess, and I don't want you to say things that are outside of your area of expertise. Okay.
As I understand it, that means certified as a professional that things are more likely than not. Is that right?
Correct. Yes. Okay. Have you reached any opinions to a reasonable degree of safety professional probability in this case?
Yes, I have.
Okay, and do those opinions relate to the cause or causes of Ms. Mulligan's fall?
Yes, that and what the store did.
Okay. Can you go through your opinions with the jury here?
Yeah, well, the summary of the opinions is that that Ms. Mulligan didn't slip on anything, that she tripped either as she was turning left to go toward the soda and the water bottles, or her bad knee gave out. She had an ACL tear, which was never repaired, and also that leads to meniscus problems and arthritis in the knee. And again, when you look at the video and through my experience and study, this is not a slip. This is sort of a stumble again, I can't say whether she just lost her balance or whether it's because of her bad knee, but she didn't slip on anything from the biomechanical field. And again, there's nothing that the store did that a reasonable store wouldn't do.
You're not critical of Walgreens and their maintenance program or anything of that nature?
No, they had a very detailed program to do that. I mean, they had procedures to sweep in the morning, and then later they were supposed to keep it clean as needed. Now, that's pretty much standard what you say, because as needed, you don't have detailed reports, because as needed varies. It depends on the weather, depends on the crowd in the store, and in general, it depends on the kind of store. Now, this is a drugstore I guess you could still call them drugstores, but it's not a supermarket where you have salad bars and where you have produce things where it's very likely to have matters that you could slip on the floor. So I thought what there, and you heard it, you heard Ms. Jackson talk about the safety protocols they had. I think they did everything that a reasonable store would do.
Sir, Mr. Sanders, is it fair to say that a great deal of your opinions were derived from the video, the actual store video of the event?
Yeah, it's not always that you don't have to rely on the testimony of the witnesses. You can see the action for your own eyes, as the jury has a couple times already, and I guess may again. And there are a number of things that I think are significant in the videotape.
And I'm going to stop you there because I want to get Mr. Brooks to help us with the screen share. And
is he doing the stills or the video? Either one works.
let's look at the fall mechanism itself, and that would be an exhibit 74, and it would be clip 3, which is from moment 9:22 to 9:36.
This is the video?
Yes.
Okay. Well, she's coming over now and going up to this up there. And where she's standing is where the debris was swept up, that part.
Okay. Now the
Now
fall
she walks,
itself,
now's where she starts to stumble. And again, that's so abrupt. It's not consistent with slipping where her foot would go back or she would go back, but it's much more consistent. And when I think we saw before that her right ankle turned a little, and that's
Right.
consistent with either just losing her balance or that bad right knee giving out because she has had an ACL which had never been surgically repaired.
right? And I want to show the exhibit 74 sub 4, which is the 9:34 mark of that video. And is this what you were talking about, Mr. Brooks?
I don't see it yet.
Yes.
I mean, I can describe it if we can't get it up.
It's a still shot.
Okay, let's see what we got. See how Ted's doing with it. There we go. Yeah, you see where she's walking. She's turning a little to the left to get behind the customer, and you can also see the cashier looking over at either the register or the customer. Now, back where the front of the cart is, that area down below is what they saw and what they swept out. Now, it's pretty obvious there's no 8-foot pile there. I mean, that's bigger than a curb. Yeah, good. Thanks, Ted. That's the circle is where you'll see later where they went to sweep things up. So it looks like she didn't fall, even if there was some debris there. That isn't what caused her to fall and where she fell.
Okay. And I think you misspoke. It was an 8-inch pile, right? Not 8 foot.
Oh, I'm sorry. Yeah, 8-inch.
That would be a wall.
I'm telling you, it's just as likely to have been 8 feet as it would have been 8 inches without somebody seeing it.
Okay. Now, Mr. Brooks, can you go to the next frame where it shows the foot going inward? Okay. Is that the moment of this mechanism of stumbling?
Yeah, that's where I think the knee was going.
Okay. And Mr. Sanders, do you see any whether
And her
it's
ankles turned too. You can see that.
yes, regardless of the size
The
of
ankle
the
turning
pile?
could have caused the knee or vice versa. I just can't say.
All right. Do you see any pile of debris anywhere near Ms. Mulligan?
Nope.
And you look for that in all the times that you've gone through the video?
Of course.
And then she stumbles forward, and we can show that. We've showed that a few times. I want to go back.
The sodas are a little to her left, as is the water bottles.
All
So
right.
she's kind of turning left.
Right. Now, you've had an opportunity to determine what Ms. Jackson did that day, the cashier. And did you see in the video Ms. Jackson sweeping a different area?
Well, you can see it on the film. It's behind the register, which is behind Ms. Mulligan on the exhibit that's up.
Right.
She's
I want to.
sweeping up and
We're going to
down.
ask Mr. Brooks to pull up Exhibit 74, Clip 2. Actually, I'm sorry. It's Clip 1, Mr. Brooks. And that's Ms. Mulligan with the broom, right?
Yeah, she's going over to sweep up the other.
I'm sorry, Ms. Jackson with the broom.
Actually, the other aisle. And people are coming along, they don't see anything. I mean, in front of the instant register. That's register 3, I think. And then pretty soon a customer comes along, if I remember.
And to get there, Ms. Jackson walked right in the area where the plaintiff ultimately fell, correct?
The customer goes to where she is, but she's not, that register isn't open. Whoops.
Okay. Mr. Brooks, if you could put up just the end of that again. The end of clip 1. At the very end.
Here he comes.
Okay. So
Oops.
the pan there, the dustpan there, do you see debris in the dustpan that she's sweeping into?
It's kind of hard to see, but I think there's a little, yeah.
Okay. And then a customer comes and clip number 2, Mr. Brooks, 74-2. What are we seeing here?
There's a little moment before that where she pointed to the guy to go over to her register, and she walked over, but she left the dustpan back where it was.
Okay. All right. Now I want to go
She's
forward
turning
to,
around, so she wouldn't have seen Ms. Mulligan.
okay. And I want to go to still number 10, Brooks. And this is a moment before, is this the moment before she starts sweeping?
I really am not sure. I think that's after Ms. Mulligan fell, and she came back, and when she was pointed to some stuff to accommodate the customers, she started sweeping it up. This is I think the end of her sweeping process, if I recall, and she never dumped anything beforehand.
Right. She never dumped the debris that was in the dustpan from before, correct?
Correct.
All right. Now let's look at the area that Ms. Jackson swept, and that would be 74-9, Mr. Brooks.
There's something else that showed on the video, which is that it looked like Ms. Mulligan didn't see what happened when she came back because she took her foot to try and see what happened. And the part that she looked at is right where she's standing in this picture, a little further to the left because she had moved her cart. But again, it isn't where she slipped.
Okay. The clip that Mr. Brooks has up now, which is I believe 74-9, that is before Ms. Jackson began sweeping, correct?
I don't think so.
Okay, well, let's go back because this is important.
I think that's after she came back because the carts moved a little.
Okay, so I'm gonna
trying to see
go back.
what's on the counter because she did that.
Okay. I want to go back to exhibit 74-1.
That's the video?
Yeah.
And apparently there is some stuff over there because she's, sweeping pretty, for a while, which would fill up a dustpan.
In the complete video that you saw, you didn't see her dumping out the dustpan at all, did you?
No, I think it's continuous too.
Okay.
We keep it running, you'll see. She's coming back. She has the broom in the dustpan, and she puts it down because she wants to go over to take care of the customer. So she hadn't had a chance to dump it.
Now, the area that you were talking about, Ms. Jackson sweeping after the accident, I think that's 74-2, 8. Can you show that? This is her sweeping up this alleged pile of glitter and dirt. Now look when she takes out, she has the dustpan.
She sort of finishes up over there. She comes over and see she's right where the cart was, which is not where she slipped. That's where she starts sweeping. And there's the woman, again, feeling with her foot. I mean, certainly you don't see any 8-inch pile. And she's feeling with her foot to see what happened. But it didn't happen there.
And I want to focus now on when she goes and retrieves the dustpan.
Yeah, see, she moved the cart there a little bit.
So she's sweeping the entire area.
Yep.
Now watch the dustpan. Oh, okay.
Well, having said, I think the jury saw the whole thing. The dustpan never moved.
Okay. All right. The floor surface itself was an anti-slip vinyl floor tile. Mr. Fieldman testified to that. Are you critical of that, the selection of that floor material?
No, and he wasn't either in his report. Now he seems to think the dirt on top of it makes it slippery, but that's the standard tile you use all over.
Okay. Do you have any other opinions that you think would be helpful for the jury about this case?
Well, to summarize, first, Ms. Jackson, she said she walked back and forth several times, and we saw her walking over just in the video. And if it was an 8-inch pile or even any significant dirt and glitter, she'd have seen it. And we know that, she sees something, she sweeps it up. The other thing is again, from my experience, I mean, although I do some human factors, mine is a little more from my experience, more engineering, what biomechanics and that kind of a thing. The way she fell is much more consistent with either losing your balance or having a bad knee go out on you than it is a slip and fall. And again, the area where anything isn't where she fell. So for those reasons, I'm pretty well convinced that this was certainly not a slip and fall on dirt and glitter where she said there was a big pile.
Mr. Fieldman testified earlier today that he believed that the instructions to store employees for cleaning up the floor and maintaining it was vague and not clear and unfair to customers. What's your opinion about that?
Well, I've worked with Carl a bunch of times. We've been on the same side because I do the biomechanics and the other stuff, and he does the human factors as to where you place things and what people think about it. And Carl's a great witness and a good guy. I really like him. But in this case, I just think he's wrong. There was a very detailed manual. And again, I think what he's criticizing is the as needed part. But that's all you can do. I mean, you don't have a detailed thing of if this happens, if there's 2 inches of rain, you do this. If it's 60% of people in there, you do it as needed. And there were safety instructions. You heard Ms. Jackson say she walked back and forth several times, and she didn't see anything, and we didn't see anything on the video. And other people in the store are looking at things. And again, it's a drugstore. It's not a food place or I mean, some food, of course, these days, or things that would fall that are likely to be slippery. So I disagree that the instructions were wrong or that anybody in the store did anything wrong.
Thank you, Mr. Sanders. I have nothing further.
Ms. Hayes, would you like to cross?
Yes, Your Honor. Mr. Sanders, do you remember when I took your deposition and you answered questions under oath?
Sure.
And I asked you on what you were basing your opinion that Miss Mulligan's accident was not the result of a dangerous condition. Do you remember that?
Sure.
And you told me that you were basing that opinion on the fact that you couldn't see any debris on the video, correct?
That's part of it, yeah. And that's one of the main things, yes.
And wait. Are you able to see me, sir?
I can't.
I can see you on the small screen, yeah. You're okay.
Okay. And Mr. Sanders, you said you couldn't see any indication that the cashier, Miss Jackson, had actually swept up any debris after Miss Mulligan showed her what she slipped on, correct?
Well, I don't exactly remember word for word what I said, but basically it's pretty clear that she swept up, she came in, she was sweeping a lot at the other aisle, and she came in and swept up something here. She swept up all over, but you couldn't see what she was sweeping up.
Your Honor, I'd like to move to strike this as non-responsive.
Overruled.
Okay. I asked you if there was anything else on which you based your opinion on, and you said no. Do you remember that?
No, I don't.
Mr. Sanders, you
Not disputing, I
testified
don't remember.
you testified a few minutes ago that the floor couldn't have been slippery because other people were walking near that area and didn't slip, correct?
Oh, I don't think I said that, but that's another point. Yeah, I don't think I mentioned that in the direct, but yeah, I think that there were a lot of people walking back and forth and nobody else seemed to fall. That's a minor factor, but it's a factor.
Are you aware of the footwear Miss Mulligan was wearing that day?
Someplace I think I saw in a deposition that it was this kind of a standard shoe with a low heel, but I don't think that had anything to do, that really didn't seem to be, it wasn't a very slippery shoe, and at the same time, it wasn't a sneaker.
Did you ever request those shoes to conduct any testing of the soles?
Well, if it looks like somebody slipped on because of slippery soles, yeah, I'd look at it.
Did you ever see any photographs of the shoes she was wearing?
I didn't check the shoes the way President Trump did when he was walking down that path a while ago.
Okay. Mr. Sanders, what is the responsibility of a customer in a store like Walgreens?
Well, it's the responsibility of the store is to be reasonable, and the responsibility of the customer is to be reasonable. Like, you don't go walking around concentrating on your cell phone when there's stuff around. You watch where you're going. You can't see everything, but you do the best you can.
And you're here today to testify as an expert in human factors, right?
No, not completely. I am a safety professional, a certified safety professional. That includes human factors, but there's more than that. And I think, to be fair, I think Carl Fieldman also, although he's human factors, deals with some of the other things as well. If you're doing this for 25 plus for him and 35 for me, you sort of get the disciplines together.
Sir, is it a shopper's responsibility to sweep up dirt or debris that's on the floor?
No.
And whose responsibility is that?
Well, if there's a reasonable time for the store to see it, it's the store's responsibility. But you can't watch every square foot in a whole store every second. So sometimes it often happens at the, in a supermarket at the produce thing where something slips, and if it happens right after that, there's just nothing the store can do, and that's the standard for the store, to be reasonable in looking at things.
Thank you. You've answered. No further questions, Your Honor.
Any redirect?
Yes, Your Honor, briefly. Mr. Sanders, is it reasonable to assume that just because a cashier like Ms. Jackson sweeps an area in response to a customer's claim that there's something there, that actually means that there was an amount of dirt there that constituted a dangerous condition?
Well, no, because you want to be nice to customers, particularly the ones that you know and are regular customers. So if she says there's something there, you sweep it up.
Thank you. I don't have anything further.
Any recross?
No, Your Honor.
All right. Thank you, Mr. Sanders. You're excused.
Thank you.
All right. Do we have any further witnesses?
No, Your Honor, the defense rests.
Okay, both sides have rested. So at this point in time, ladies and gentlemen of the jury, I'm going to give you the jury instructions that apply, and I think they're going to put them up on the screen as I read them. I'll wait until they get them up, and then I will start reading them to you. This is always the most fun part of my case. Okay, ladies and gentlemen, I will now instruct you on the law governing this case. You must arrive at a verdict by a vote of at least 9 members of the jury on each question asked within the special verdict form, which we'll cover after you we hear closing argument. The plaintiff, Deborah Mulligan, filed a claim against the defendant, Walgreens, for injuries she received when she fell at a Walgreens store. Walgreens denies it is at fault for the injuries Deborah Mulligan claims. Deborah Mulligan claims that Walgreens was negligent in operation of the store where she fell, which resulted in her injuries. In order to prove her claim of negligence, she must prove the following: that Walgreens was negligent, that she was harmed, and that Walgreens' negligence was a factual cause of her harm. Negligence is a failure to use reasonable care to prevent harm to oneself or to others. A person can be negligent by acting or failing to act. A person is negligent if that person does something that a reasonably careful person would not do in the same situation, or fails to do something that a reasonably careful person would do in the same situation. To be a factual cause, the conduct must have been actual, real factor in causing the harm, even if the result is unusual or unexpected. A factual cause cannot be an imaginary or fanciful factor having no connection or only an insignificant connection with the harm. More than one factual cause may be involved in causing the resulting harm. A person who controls property is negligent if that person fails to use reasonable care to keep the property in a reasonably safe condition. A person who controls property must use reasonable care to discover any unsafe conditions and to repair, replace, or give adequate warning of anything that could be reasonably expected to harm others. If you determine that a dangerous condition of the Walgreens store existed before it caused injuries to the plaintiff, you must determine if Walgreens was aware of the dangerous condition with sufficient time to have cured it, provide protection from it, or adequately warn of the condition before the plaintiff fell and was injured. If so, then Walgreens is liable for the resulting injuries. This is a truncated trial addressing only whether Walgreens was negligent and whether Walgreens' negligence was a factual cause in the injuries received by Deborah Mulligan. We are not asking you at this time to consider the amount of damages, if any, which should be awarded for her injuries. You have also not heard from all witnesses who may have information about the matter. A party must persuade you that what the party is required to prove is more likely to be true than not. This is referred to as the burden of proof. After weighing all of the evidence, if you cannot decide that something is more likely to be true than not, you must conclude that the party did not prove it. You have heard witnesses testify in this matter. You will have to decide whether you believe each witness and how important each witness' testimony is to the case. You may believe all, part, or none of a witness's testimony. In deciding whether to believe a witness's testimony, you may consider, among other factors, the following: how well the witness saw, heard, or otherwise sensed what he or she described in court. How well did the witness remember and describe what happened? How did the witness look, act, and speak while testifying? Did the witness have any reason to say something that was not true? For example, did the witness show any bias or prejudice, or have a personal relationship with any of the parties involved in the case, or have a personal stake in how this case is decided? Finally, what was the witness's attitude toward this case or about giving testimony? Now that you've been instructed on the law, the attorneys have an opportunity to make closing arguments. Plaintiff's counsel will go first, and then defense counsel. Remember now, this is closing argument. You have heard all of the evidence. What the attorneys say is not evidence in and of itself. They can refer to the evidence. So, Ms. Hayes, are you ready to proceed?
Your Honor, this is the technical bailiff. I'm just going to break in and note that it has been decided we are going to take a short break at this point
Then do so.
to give the attorneys an opportunity to prepare themselves for closing argument. The
Let's
time is,
return.
yes, the
Okay.
time is now 2:05, and I believe that we have time to have a 10-minute break, Your Honor.
Let's do it. We'll come back at 1:15. Thank you. And remember, ladies and gentlemen, the jury, don't discuss the matter amongst yourselves or with anyone else, and don't form or express any opinions or conclusions until the matter has been finally submitted to you. Okay, we're on break.